University. I, Jyoti Srivastava, Assistant Professor, Computer Science and Engineering Department, would like to welcome all the dignitaries on the dais. Mr. Anshul Verma, sir, our today's speaker. He is examiner at Patents and Design at Indian Patent Office. Dr. Amish Vyas, sir, he is Registrar, Indrashil University and Dean School of Engineering. Dr. Siddeshwar Rautre, sir, he is Associate Professor at Indrashil University and today's convener also. And all the participants in today's webinar for National IPR Awareness Program. IPR stands for Intellectual Property Rights. I would like to inform all the participants that our today's program is organized on the occasion of World IP Day during the IP Literacy Week celebration under KAPILA campaign. KAPILA stands for Kalam Program for Intellectual Property Literacy and Awareness. Now, I invite Dr. A.P. Vyas sir to give opening remarks for today's event and kindly introduce our today's speaker to all the participants. Over to you, sir.
Thank you, Jyoti. And am I audible?
Yes, sir, you are properly audible.
Okay. So thank you and welcome, Mr. Anshul Verma. Anshulji, welcome to the Indrashil University. It's a great day and great time for us also that now we are collaborating with AICTE rather than just getting approval. We are now collaborating with it. So it's a great time for all of us. And formally, I would like to invite all to the IPR Awareness Program jointly organized by the Indian Patent Office, AICTE and Indrashil University. And I'm sure it is a time where one should understand what is IPR because world is looking at the India for new generation research activities. So in this time, IPR is very important. And this program will be conducted on the occasion of World IP Day. So this is the right time and right occasion. And during the IP Literacy Week celebration under the Kalam Program for Intellectual Property Literacy and Awareness Campaign, that is the KAPILA started by AICTE. So I would like to thank AICTE also for selecting Indrashil University for such kind of awareness program. I would like to just introduce the speaker, Mr. Anshul Verma. Anshul Verma is a BTech in Mechanical Engineering, MTech in Mechanical Engineering, with specialization in machine design from the IIT Kochi.
To celebrate the International IP Day.
He is working as a gazetted class 1 officer under Ministry of Commerce and Industry at Indian Patent Office. He is also examiner for patents and design since last 4+ years. So once again, welcome Anshulji, and people are waiting to hear you. So all stage is yours now. Thank you very much.
Thank you so much, sir. Thank you so much for the introduction. And I humbly apologize for the delay. There has been a blackout in Mumbai, in Navi Mumbai area, so even we could not help in that. Okay, so since we have started, and thank you so much for the introduction, I would like to appreciate the work done by Dr. Siddeshwar as well for coordinating this session with us.
Excuse me, sir. Sorry to interrupt.
Today's IP Day, and regarding IP,
am I audible, sir?
Ma'am, you're saying something?
Yes, sir. Sorry to interrupt. Actually, there are few directions to be given by Dr. Siddeshwar Rautre, sir. So,
Sure.
Okay, fine. Thank you, sir.
Yeah.
So, thank you so much, Amish, sir. Now, I would like to invite Dr. Siddeshwar Rautre, sir, convener for today's event, to share his views on today's event. Sir, over to you.
Good morning, all. Honorable Registrar, Indrashil University, Dr. Amish Vyas, sir, Speaker of the event, Mr. Anshul Verma, all the faculty members, students, and all participants. I, Dr. Siddeshwar Rautre, Associate Professor in Computer Science and Engineering Department and Coordinator of the event. On behalf of Indrashil University, welcome you all to the IPR Awareness Program under National Intellectual Property Awareness Mission, jointly organized by Ministry of Education's Innovation Cell, MIC, AICTE, DPIIT, Indian Patent Office IPO. I'm thankful to the Indian Patent Office IPO for selecting our university as the host institution to conduct this event. So in this event, certificates will be provided to the attendees of the program, certificate of appreciation to the university, participation certificate to students and faculty members, certificate to the coordinator. So I request to all the participants who have not completed the registration process to complete it. The certificate will be sent to the registered email ID from Indian Patent Office directly. So I hope this will be an interesting and informative session. Now I request Mr. Anshul Verma to start the session. Over to you, sir.
Well, thank you so much. Thank you so much once again for the introduction. And again, I would like to humbly apologize for the delay and thank you for staying there. Well, let me just share the screen. Is it visible? The screen is visible to everyone?
Yes, yes, sir.
Yes, sir.
This,
It is.
NIPAM National Intellectual Property Awareness Mission, this presentation, it's visible to all of you, right?
Yes, sir. It is.
Okay. Well, thank you so much. So let's begin. So the office, Indian Patent Office, which deals in the intellectual property, there's this mission run by the government of India to provide awareness to each and every citizen of our country. It is not just limited to the institutions, though you are an institution, but we want to propagate this mission throughout the country, because property is something that we buy. For example, if you have a pen, you have a mobile phone, that is your property. You have a piece of land or a flat, that is your property, no doubt. But any property that belongs to you because of your intellect is called intellectual property. And irrespective of the age, irrespective of the qualification, must I say, irrespective of everything, intellect is something that is with everybody, because we all have brains, right? So any property that comes from your intellect becomes your intellectual property. And there's a need in today's world where we need to put forth the population, the demography of India towards intellectual property development. So we'll see how things will unfold in this PPT. So here's this mission called NIPAM, National Intellectual Property Awareness Mission. Under this mission, we are propagating the idea of intellectual property throughout India. Okay. So this is the logo of intellectual property. So if you can see this logo, this IP, I hope my cursor is also visible. On this I, there is this circle. In this circle, there is a diagram. Can anybody tell me what diagram it is? It's okay if you can unmute and speak. What is in this I? Like, the esteemed faculty is also allowed to speak up. They can say whenever they want to say anything in between. It's all right with me. So can you see that I? Can anybody tell me what is in that I? Any guess if somebody wants to make? Am I audible?
Yes, sir. You are audible.
So
Yes,
anybody wants to guess?
You are audible. You are audible, Anshulji. Only a thing, since it is webinar, people can only chat. They can't.
Okay. They do not. Okay, they have not been allowed to unmute.
Yeah,
Okay.
yeah.
Participants can write in chat box.
They can write in chats.
Yeah, sure, they can actually. Anyways, this eye, if you can see this picture, this circle enclose a brain. So when I say a brain means something from which you provide your intellect, from which you think. So anything that comes from your brain, that is anything that comes from your intellect, becomes your intellectual property. And that is what the logo is actually, for intellectual property. Okay. There's this misconception actually when we talk of intellectual property, be it in regards of patents, because majority of the people here are doctorate and professionals, so they must be knowing what patents are. So there's this misconception among citizens that patent is something that is granted only for those who are highly educated and having technically sound background. But if you can see this, sorry, I don't know how to go back in this. Just a moment. Yeah, if you can see this this patent was filed in 1919, and you can see it's boldly, clearly written paperclip. And paperclip is such a very simple thing that even if you ask a 5 or 6-year-old boy or a girl how you can hold few papers, even they know that they can use a pen, and that clip of a pen, they can hold certain number of papers. So the same thing has actually been filed by a person in 1919. Okay, so it does not mean that patents or technology something has to do with highly technical things. It can be as simple as a paperclip. Okay, and one more interesting thing over here is, if you can see this number, it was filed in 1919. So you can see how old this paperclip is. It was filed in 1919. That is, patent was granted for paperclip. In 1919, if you go back towards history, you can remember 1919 was the year when we were fighting against Britishers, and Jallianwala Bagh incident took place in Amritsar, right? So we were fighting against Britishers for our independence, and the Western world, they knew the importance of intellectual property. They knew the importance of patents, trademarks, all the intellectual property rights. Since then, they have been, producing technology, and they have been getting registered it on their names. And that is why this is one of the reasons why India still is a developing country, not a developed one. Like if you talk of United States of America or United Kingdom or Japan or Australia or Canada or any European big country, these countries have already initiated the process of intellectual property. You can see the year 1919. When if you in that year, if you ask somebody about intellectual property, people would have rather said, what is this? We are dealing with our independence, and what is this intellectual property? And this is one of the reasons why we are still developing. Okay. So this is how old intellectual property is there in the world. And but even today in 2022, we are organizing this awareness mission just to make people aware what is intellectual property and why it is important. Now, if we talk of innovation index, there is this global innovation index. Okay, it is by WIPO, that's World Intellectual Property Organization. They put under certain criteria and they give rankings to each and every country. Now, if you can see in 2020, the ranking of India was 48. Now, for a country which is 7th largest and about to overtake China in population, this number just does not justify. Okay, because it is 48th rank we are having, and we are having a very huge population. In fact, it is said that India is a country which maximum young demography. Okay, if I talk of the first country who is number 1 in innovation index, that is Switzerland, and the size of Switzerland is even less than the size of state Haryana. So you can understand that why we are so much lacking in intellectual property, because there is no awareness of that. And that is why this mission NIPAM is there by the government of India, so that we can also improve our rankings. Okay, now I think this is 2020, the ranking is 48, but in 2021, the ranking improved to 46. So when we talk of intellectual property, there are certain types of properties. For example, patents, designs, trademarks, geographical indications, and copyrights. Okay, we'll go through one by one. Just for your reference, if you talk of an Apple laptop or a MacBook, so you can see that it has an LED screen, right? LED screen is covered under patents because that is a technology. Now there is a particular shape of a laptop. If you compare a laptop of HP or a Samsung or Dell with MacBook, there is a difference in design. So that design is also covered under intellectual property. For example, if you compare an iPhone with another Samsung phone, there is a certain difference in design. Okay, so design is also covered. Then there is this logo. We all recognize this logo. That's the Apple logo. This comes under trademark. This is also a intellectual property. And the other thing is user manual. User manual is like, it's with everybody that belongs to a particular product, that comes under copyright. So this is just for your example, for reference, how different intellectual properties are, in one single product. So like I have earlier said, intellectual property is something that comes from the intellect, that is by application of your brain and with the resources that you have. It is not that you must be aware of this, that ISRO reached Mars with so much less amount by spending a very less amount as compared to the NASA. In fact, NASA also appreciated that fact. So applying your brain with the required resources, not extravaganza resources, like we have infinite resources, with the limited resources and with all the labor that you do, and you come out with a product, with a process, with something innovative, that becomes your intellectual property. And it can be in any domain, be it in the patents or trademarks or copyright. Right? Now, there is one question asked, then why should we protect our intellectual property? Now, if I give an example, if you are taking a class and teacher gives an assignment, there are only 2-3 students in the class who genuinely do that assignment, right? Rest of the students actually copy that. There's some guilt feeling among those 2-3 students that I did all the labor and rest all copied it from me, and they also got the good mark, the same and good marks. So what this intellectual property rights give you, it gives you protection. It gives you a special privilege, a special right, that only you are the authorized user of it. Only you can use it. Only you can take benefit out of it. All right. And you can use it for commercial purposes. What you can do, there are like how to utilize and commercialize your stuff is if, for example, you come up with a technology, you can use it, you can assign it for somebody else. Like we see a lot of McDonald's or KFC outlets out there. It is not that the CEO of the McDonald's or KFC comes to India and they sit in that outlet. What they do is they give it as a franchisee to different people. Okay, these are different scenarios in which you can use your intellectual property. Like okay, everybody is doctor over here. I think majority of the people, they have done their research and doctorate as well. So when I was doing my master's, right, I had 2 things in my mind, and those 2 things I have written over here. Academically, I was supposed to publish 2 research papers in a good research journal having good impact factor. I did that. So academics, I scored gold. Second is the pride among my fellow friends and other students, that I have 2 research papers. I have that pride, and academically it was sound. But that is what the thinking of a common person, right? What a businessman would do is they would commercialize that thing. They would make a brand value out of it. Okay, and they could earn it. Like these days, there's this Shark Tank. This is nothing, simply just innovative things. They came up with innovative things and they present the idea to the judges and they put investment into it. It is not limited to publishing papers and limited to just developing technology and then keeping it aside in libraries. How to commercialize it, how to earn, how to invest in it. Okay, so this is the whole concept of intellectual property. Otherwise, there is no need of intellectual property. So first of all, let us begin with the patents. So patents is basically granted for inventions or any technology or any product. Okay. Patents, when you're granted a patent, you have to disclose what your work is. Okay. For example, if I talk of Samsung is recently developing this foldable screens, right? We all know that the screens can be folded. So for that, Samsung has to provide with our office the proper, detailed description how they achieved that. So that is what is called exchange for disclosing it in the patent. They have to disclose their invention to our office, and in exchange of that, we will be providing them with a patent that only Samsung is the authorized, organization who can use that invention for their commercial output, for their commercial benefit. And it should be described in such a way that any ordinary person who is skilled in the art can also reproduce it. Okay. Though it is written that any ordinary person can reproduce it, it does not mean that every ordinary person can be reproducing it and using it for their own self. No, because a patent has been granted, so they are the only authorized user. So that is what a patent is granted for. Okay, technology. And patent is also granted in a sovereign state within boundaries. For example, if you're filing for a patent in India, it will be granted in the geographical boundaries of India. Anybody in China can copy that. Anybody in UK can copy that. But you can see that majority of big car manufacturers, for example, they file patent in all the countries because they have their manufacturing units and market in every country. So to protect themselves against somebody who could copy, so they have to file patent in every country. So that is the concept of patents. You have to go in every country where you want your product to be in the market. Okay. It basically gives you an exclusive right that you are the only owner. So that is what is about patent. Patents is basically in India, particularly if I talk of, the first patent was granted in the year 1856. Now again, 1856, you can think of the year. Even 1 year before the Mangal Pandey mutiny, the very famous movie of Mangal Pandey, in fact, we all must be knowing that. Even before that, this person, Alfred D. Penning, he asked for a patent for from government of India at that time. And what the patent was all about, an efficient pankha pulling machine. It was a very simple invention in which a person sitting idle just has to rotate his hand, and there will be a fan or multiple fans attached with different assemblies, and there will be fan like without electricity, fan will operate. So this very simple invention got patent. So once again, I would like to say that patents is not something that is granted for heavy technologies, something related to like time machine or aeroplane or like that. That's also there. But patents can be as simple as this machine, or as simple like I have shown you, a paperclip. These are some of the famous inventions like aeroplane, Wright brothers, Alexander Graham Bell, telephone, phonograph. All right, these are some of the very famous inventions. We all know it. In India also, if we talk about Indian invention like nano car, and how nano car is an invention, it is just a usual car. But the point is, you can buy this car at the price of a bike. So patent is not only about making something new every time. Patents is also granted if there is an improvement over previous invention. Okay, because whenever we write a research paper or whenever we do research in a master's or postdoctorate, we do have some background. We do some research study, some background study, different papers. We go through it, and then we come to a new thing which could be a betterment or an improvement of the previous invention, right? So that is also granted. That is also covered under patents. Like this hepatitis vaccine, Jaipuri foot. Now see the price of this Jaipur foot. It is only $28. It is even less than 2,500 rupees. 2500 rupees se kam mein anybody can afford this prosthetic leg. So you see, patents for invention, yes, patents if you make an invention more improved, and patent is also for if you are making a product very cheaply. Okay, so these are also some of the examples. Now you can see the very first example. In India, what we do is, if it is raining, we can use a book to cover our eyes if we are going in rain, or we can use our hand. That is what we do, right? And genuinely everybody knows it, how to cover your head or face. Like people in movies, you must have seen they are using poly bags apne upar rakh lete hain. But in Japan, what people did is they created a simple cap, and this very simple cap, I don't think it is new to everybody can understand with the diagram. This simple cap has been given patent, and people are earning out of it. Okay, and this wristband through which we can project our phone or on our wrist, this is definitely a highly technical invention. Patent has been granted. Now this cap, a very simple invention, again the patent has also been granted to it as well. Now comes the drone technology which is there these days, and this credit card machine that can be used in mobile. So technology can be of any sort, as simple as this cap or a paper clip, or as high tech as this drone. Okay, patent is granted for it. Now there is this procedure and how to file a patent. This question comes to everybody. For example, if there's a third year, fourth year student, they have come up with a project and they want to file a patent. So this is what I'll be telling you over here, how to file patents. So there are few number of forms that we have to file. First of all is the form 1. Okay, form 1 is basically in which we have to give our details, key, who is the applicant, who is the inventor, what is the title of your invention, okay, your details. When I say applicant and inventor, look, if I talk of a company, for example, let's say Samsung again. Samsung is a company, but it is not that Samsung is created something. There are employees in that company who create those things. So those employees, for example, if I am working with Samsung and I create this foldable screen, so I will be the inventor of that particular invention. And when I want to file a patent, I will be called as the inventor, but Samsung company will be called as the applicant. Okay. And similarly, in the case of college and universities, the faculty or the student who has filed for the patent, they will be called inventor, and the college name or the university name will be called as the applicant. So there's a difference between applicant and the inventor. In form 1, it is the basic details that we give. All right. In form 2, we have to give the details of our invention. Form 2 is basically like your thesis work. All right, in which you write things like it includes title, background of the invention. If there are some certain drawings, you have to briefly describe all those drawings. All right. Then the description, how you have achieved that very product. And a few things that are very important is the claims. For example, if I make a car and I have written down 50-60 pages of my invention, let's say thesis, it is similar to thesis only, and there are 50-60 pages. Okay. So patent will not be granted for those 50-60 pages. All right. Patent is granted for what new you have done. For example, if you write in the description that I have used nuts and bolts, I have tightened them with a wrench. So that is something that is obviously known. Everybody in the public knows about it, that nuts and bolts are used to bolt two things together. So patent will not be granted for that. But the patent will be granted what you have achieved out of that. And what you have achieved is written in these claims. Okay. Sorry. So in these claims, we actually pinpoint those inventions, those particular things in which patent will be granted. Out of 50-60 pages that you have submitted under form 2, there will be like 5, 6 or 10, 20 claims. On those claims only the patent is granted. Okay. And there is fees for application. Like with form 1, you have to submit some certain amount of fees. With form 1, you have to pay a certain amount of fees. With form 2, there is no fees, as long as your description contains only 30 pages and a maximum of 10 claims. If you are submitting your invention having more than 10 claims, then per claim there will be charges. And if there are more than 30 pages of description, per page extra, that like 31, 32 per page, there will be extra charges. After 30 pages and 10 claims, there won't be any charges. Then there is something called form 3. Form 3 is basically if you, because patent is something that is not limited to any country. A company files for patent in US as well as India. Okay, so in form 3, we want the details of their foreign filings, whether you have filed in another country or not. All right. Then comes form 5. Form 5 is basically for the inventorship. The applicant has to declare that this and this person is the inventor. Okay, that is for form 5, and there is no fees for form 3 and for form 5. Now these are the 4 forms that are mandatory: form 1, form 2, form 3 and form 5, in which your complete work is submitted under form 2, your basic details under form 1. Now after submitting it, there is a time gap of 48 months, because sometimes what happens is, for example, if you are working on something and you think, yes, I'll get a patent on this, this is a good invention, you filed all these forms 1, 2, 3 and 5. But after a few months or after 1 year, you got to know that there has already been a patent filed for the same thing, because it is something that taking a drop out of an ocean, because you might not know that there could be patent, because it depends on the how much research you have done prior. Okay, if for example there is already an invention, but for the same patent, then why to file a patent, why to spend so much of money? So there is something called form 18. Form 18 is basically for the request of examination. When you file form 18, after that only your application is processed under our office, and we provide you with a time of 48 months. For example, if 1st January 2022 you file a patent, from that date, from 1st January 2022, from that date, 48 months, till 48 months, you can file form 18. Form 18, it is because you have certainty that there is no other invention related to this, there is no other patent granted related to this, then you can file for form 18, and after that only your patent is processed. Okay, and yes, there is a fees for form 18 as well. Like I talked about the fees, these are the forms that I just discussed, and this is the fee structure. Now there's something that the Indian government is doing. You must have heard of Startup India, Stand Up India, right? Make in India, small entities, MSMEs. So what is the point of making all these different categories of companies or right, factories? The difference is, if a foreign applicant comes to India, you can see the fees. The fees that he has to pay for form 1 is 8,000. But if you are a natural person, if you are a standalone individual, if you are a startup, if you are a small entity, or if you are an educational institution, just look at the difference in fees. The fees is only 1,600 as compared to what is paid by the company, right? Now form 18, that is what I call the form for request for examination, in which you request our office for examination. The fees is only 4,000 as compared to 20,000, that is for company. So there's a reduction of 80% in the fees, and this reduction is only because so that we can encourage our youth, our citizens of India to file more and more patents, to go through, to apply your brain more and more to different problems, so that they can come out with different solution, multiple solution, and they can get their intellectual property registered. So that is why the fees has also been reduced. Now, for the filing, like these are the different forms that you have to submit. You can either submit it directly to our office. There are 4 offices, one in Mumbai, Bombay, Kolkata, and Chennai. Or what you can do is, there's this link. You can go to our website, that is IP India. You can directly upload it over there. Okay, so that is like online and offline, both the modes are available. So this is how this online module looks like. If any of you are working on something, you can directly just make an account on our website, and you can upload your documents along with different forms and the fees. Okay. There is also something called expedited examination. Like you must have heard about it, that it takes 4 or 5 or 6 years to file a patent, because this has been a question that we often see people do ask us, why it takes so much of time. Obviously, there was some pendency and there were some issues within the office, though now it has been all cleared, and we have come up with an idea of expedited examination. For example, if you are a startup, okay, first of all, your fees is reduced. But what is the point of a startup if your invention is being granted after 5-6 years? There's no point of making a startup or a small entity. So we have done this expedited examination, in which the patent is granted within 4 to 5 months, and that comes under expedited examination. So who all are under this expedited examination? If you are a startup, if you are a small entity, or if there are like multiple individuals and one of them is a female individual, even then it will be considered under expedited examination. So if these are like government offices or government institutions, or we have also certain agreements with different countries. If patent is from those countries, they are also covered in the expedited examination. So you can see the whole picture over here is, the fees has been reduced, the awareness is being provided, and there is something called expedited examination. Means the patent will be granted within 4 to 5 months, maximum 6 months, I think, that too in very certain cases. Okay, so this is basically to encourage the public, because I have just shown you that the rank of India was 48. And for this much of population in one country, 48 rank is not justified at all. Just to improve everything within the country, okay, all these measures have been taken by the government. So right now I have told you what are the forms that you have to submit. Now this is the process, how your application is processed in our office. Okay. For example, if you're working on something and you feel like within like 5 or 6 months, I'll be done with this invention. Okay. Then you are not supposed to wait for those 5-6 months. Even if your work is not 100% complete, you can file for a patent. This is what is called provisional specification. I'm just talking about the ordinary application. Ordinary means any Indian who files for a patent comes under ordinary applicant. Okay, that is called ordinary application. Under ordinary applications, you can file provisional specification. Look, specification is your description. आप अगर कोई भी material हमें देते हैं, if there is some description in that is called specification. And provisional specification means your work is not yet completed, but you have already filed for it, and that is done to procure a date, to save a date. Because if say there are 2 competitors who are working on the same thing, one person will wait till the end, his invention is complete, then he will file. But the other one knows this provision of provisional specification, he will file immediately. Okay, and there is a time of 12 months, that is 1 year. Within 1 year, you can submit your complete specification. And that is just to save the date, to have a priority among the dates. If 2-3 person file after filing the patent and 1 person, provisionally he has filed, so the priority will be given to that individual who filed it before. Okay, so this is just to save the date, and within 1 year, you have to submit the complete specification. All right. Then after submitting complete specification, your document, your description, your application is published in the Gazette of India. And it is published after completion of 18 months. So there is this time lag of 18 months, because in the 18 months, we have to do scrutiny of that invention. Okay, we also scrutinize different invention. And after that, it is published. It comes into the domain of public, that everybody can know. If this is the invention, this has been filed for patent. After that, publication, you have to file form 18. Okay, that is for request of examination. Up till here, the process is done by all the forms except Form 18. But when we talk of examination in which your application is actually processed, you have to file Form 18 within 48 months that I just told you. Okay. In the examination, what we do is we check for the formal objections, whether the forms has been, completely filled, if there is any errors in filling up the form. We also do technical examination. In technical examination, we study your invention. Okay, we understand it and we search it on different platforms that we have in our office, and we search it throughout the globe in different countries. All right, and we see whether the same invention has already been patented or granted or available in public domain or not. If your invention is thoroughly novel means it's completely new, it has not been disclosed anywhere in the world before, in that case the patent is granted. But what happens is majority of the time there are certain defects, because there could be like defect in how to write a claim, how to write a description. There's standard format for that. So we from our side give a report that is called first examination report. Okay, we give the applicant first examination report in which we mention the objections that we are having. Now it goes to the applicant. Applicant has to reply to that first examination report within a time of 6 months. It can be extended to 9 months, that is 6 plus 3, it can be extended, but the timeline is 6 months. If you are not extending it within 6 months, the applicant has to reply to the objection that is raised by our office. Okay, now if the objections are met, all the objections are met, everything is clear, then it goes for grant. But if there are still certain objections pending, then there are second examination reports, third examination report, it goes to the hearing, and after, if everything is resolved, the case is either granted or it is rejected. It depends on the case. Okay, so this is the whole structure, how the patent, you file a patent starting from provisional specification to complete, and how you receive a patent. And this is these are like first examination report, second examination report, hearing. This is all the structure how patent applications are filed. Now this is for ordinary, I have said. Similarly, for convention and PCT also it's there, but this is basically for companies who are not in India, who are like foreign applicants who are registered in different countries. Okay, so I won't be going through that. There is also, like I mentioned before, that there is a time lag of 18 months, right? In those 18 months, what we do is we screen the applications, because it is not that every time applicant or an invention is about any random invention. It could be related to defense, it could be related to atomic energy. So in that case, what we do is we do screening, and after screening, if you come to a conclusion that this very invention is related to ammunition, we send it to DRDO, from where we need a clearance. Or for example, if there is an invention which is related to atomic energy, if this person who is working on any atomic energy stuff, we send it to atomic energy. Okay, and after getting clearance from them, if they would say that there is no issue, we finally go for the examination. Okay, so that is why that 18 months time over there, and then comes the publication. Okay, and some people also ask, what's the point of publication? You are putting my invention available to all. The point is, because there could be another person who is already, who has already filed for a patent or doing the same invention. If there are some clashes, they can go for opposition, that is called pre-grant opposition, or sometimes post-grant opposition. So that is why the applications are also published, so that public gets to know that such and such applications are coming. So I have already told you the examination in which we do the formal examination and the technical examination, then the first examination report in which we communicate the objections from our side, if we have any in your application, then you reply to it, and that is how things proceed. And finally comes the hearing and the grant or refusal. So this is how a patent is granted. Okay. This is also the same thing, technical examination. Yeah. How do we do technical examination? We read and we understand the invention in relation with the drawings. We search for it throughout different platforms, worldwide database. That is what we use. We check for the inventive step, novelty. Basically, we check whether the invention is new or not. All right. And after that, we give a first examination report to the applicant. And these are some of the timelines which I have already mentioned. First of all, this provisional to complete, like if you are in between your application, you can directly file provisional application, or right? And within 12 months or within 1 year, you have to file for the complete specification. This is just to save a date. Then Form 18, that is for request of examination. You will be granted a time period of 48 months. Only after submitting Form 18, your examination is proceeded further. Now, like I said, we give you a report that is called first examination report, and you have to reply to that report within 6 months. Okay, so these are other timelines like Form 3, which was for foreign filing, that is within 6 months you have to declare, and Form 5 within 1 month, in which the inventorship you have to declare. So these are various timelines. These initial 5-6 are the important one. Now let's discuss about designs, because patents is something that is correlated with design. If you make a machine, it is not just the machine, it is the aesthetics as well. Okay, how it looks. So anything, for example, feature of a shape, configuration, any pattern, ornament, or composition of lines or colors, it could be in 2D or 3D, okay, by an industrial process or means, and that can be judged solely by eyes. Okay, that comes under design. So if you make anything out of an industrial process that can be judged by your eyes, that is covered under design. For example, if you can see this car over here, these designs are over here. So it will be covered under design, that this very design is registered for this very car. Okay. I just forgot to mention the time period of a patent. Patents are basically granted for 20 years. If today you file a patent and you receive a patent for that, you have been granted patent for that, then that invention will be valid for next 20 years. Okay. After 20 years, that invention can be used by anyone. It is open to public. Okay. For example, nobody uses Nokia phones these days, like 3310 we used to have. अभी कोई use नहीं करता, because that technology is 20 years old and it is open in domain. If you want to make a mobile similar to that is the Nokia mobile, you can do that because it is open to public, right? Similarly, the tenure of a design is 10 years. However, it can be extended to 15 years as well. If you Google any shape of a bottle, for example, any lotion, let's say, if you look at the history of that lotion, you can see the shape of the bottle has changed throughout the years. Why? Because design is granted only for a tenure of 10 years. Okay, and extendable to 15 years. So, you know, invention is one thing that requires knowledge of a particular domain, but design, you need not to have that knowledge. You can design anything, and that can be received with design. Okay, that can be registered design. For example, if you see this sofa set, so nobody would ever have thought of mask. Mask can also be registered under design. Okay, there are certain different types of mask, flask, there's a perfume bottle, this bicycle, wristwatch, anything, any design that you see around you is covered under design. We actually do not, as a layman individual person, we do not have idea that these all things are also registered. But any design is a complete set. So a design is granted for a complete set, not for an individual entity. Okay, for example, this tea set, the design is granted for the complete set. Okay, not for every single plate or every single cup or bowl. Like sofa set, jewelry set, I just said. No, patent can be filed in any 4 offices of our in our country. But for design, you can file anywhere in the country, but it eventually goes to our office in Kolkata, because Kolkata is the designated office where designs are processed. Okay. Similar to patents, this is the filing procedure for design as well. The fees is like 1,000 rupees. You can see how minimal the fees is. 1,000 rupees for an individual or a small entity or a startup. And if it is a big company, the fees is 4,000. And similar to patents, Form 1, you have to give your details and everything, every detail about your design, what the design is all about. This is just for your reference, how it is submitted. This is the design. Okay. And you have to write it is a teapot and everything, all these simple things. You just have to submit the design. There is no technicality behind that you have to submit as compared to patents. Okay. And this is how a certificate of design looks like. And similar is the certificate of a patent. Now, if you might have noticed, sometimes you could see on the chair of Neel Kamal, there is this engraved Neel Kamal, or on certain design, you have seen a number, or you could see that registered RD or REGD dot engraved over those products. It means those products are registered. Okay. There are certain questions from people. I'll just go through those questions later on. Okay. So basically what I mean to say over here is, if your design is registered, you can mark that design, you can mark that number, or you can mark with all these RD registered, REGD death on that very product, so that people got to know that this particular product is registered and we cannot make a copy of it. Okay. Time similar to the patent, this is the timeline, like within 6 months you reply, like in the case of patent, you have to reply to the FER, first examination report. Similarly is the case of design, in which you have to reply to the objections within 6 months. And the tenure, the difference only is the tenure. Like patent is for 20 years, the design is for 10 years and can be extended to 5 years. Now comes the trademark. Trademarks are actually very interesting, because this is what we see in our everyday life. Just look around you, you must be noticing, for example, in front of me, there are two systems. One is HP, one is Dell. These two are the famous trademarks, and we can recognize, okay, this is the HP company, this is the Dell company. I have a water bottle over here and it's written Milton over here. Milton is nothing but a trademark. So trademark is very common thing that we see every day. Your mobile phone, it also belongs to a company, and that logo of the company is nothing but a trademark. So trademark is basically, it could be any word, name, symbol, or device, or any combination of them, which identifies one product or one service from another. Okay. It provides exclusive monopoly over a class of goods or services. For example, if you want to courier something, so you will say DHL, I'll courier something from DHL. Okay, because we trust that brand, because that brand has a trademark, that brand has a value, and that brand value comes only from the trademarks. Okay, I'll give you more examples for that. It is basically how we also connect to a product. Okay, it allows a business entity in building public goodwill and brand reputation. For example, Adidas, we know the products of Adidas is good, the product of a Reebok is good, because that's a brand value associated with that product, and that brand value comes only because of the trademark. Now these are certain types of trademarks. For example, trade names, collective marks, certification mark, tagline, shape, sound marks. So if to say, like this logo of McDonald's, this is a registered trademark. So this is something, the power of intellectual property. If you see, if you come up with a technology, that is just a patent. Okay, but what you can do is, if it's a machine, so you can provide that machine with certain features, certain design, that is also registered under intellectual property. Now if you open a company, if you open a startup, you can give a logo to that startup, that comes under trademark. Okay, and why this is necessary is, in fact, in our what I must say is, when we are sitting idle, we are doing nothing. In that time also, we have that phrases in our mind. For example, if I talk of tagline, "Ye dil mange more," कोई सिर्फ इतना बोलेगा, "Ye dil mange more," and you can recognize it is Pepsi. That is how things actually, these companies work. They use the best out of the intellectual property. "Ye dil mange more," and "Zindagi ke saath bhi, zindagi ke baad bhi." So these are nothing. We do not need to learn it. This is what we come across in our life, and that is how we relate ourselves with that product. Okay. So certification mark, collective mark like Google. Certification mark like Bureau of Indian Standard. This is a certification mark. Tagline like McDonald's, "I'm loving it." Nike, "Just do it." So even a child might not be knowing that this is a trademark. He or she knows the slogan, "Just do it." And that is the power of a trademark. Okay. Shapes like this Coca-Cola bottle, this also has a shape. This shape is also a trademark. Somebody might be saying it comes under design. Yes, bottles does come under design, but the shape of Coca-Cola is so much famous that it eventually comes under trademark. This shape is the trademark of Coca-Cola bottle. And sound marks, for example, if you see any movie, Fast Phantom, there are so many Bollywood movies in India, and this MGM lion that rose in certain movies of Bollywood. In fact, if any of you is having Apple mobile phone, I could easily say that more than 90% of the Apple phone users have the same ringtone. Why? Because that ringtone is the sound mark. Okay. So this is the power of intellectual property when we talk of trademarks. Now, there's something called a good trademark and a bad trademark. Your trademark should be different. It should not be like deceptive, or it should not be like similar to any other trademark. For example, in India, we have seen in market, there are t-shirts. Instead of Adidas, it will be written Abibas, right? There are shoes in markets. Instead of Reebok, they will be written Reebok. So that is, this is the first hand or second hand copy. That is what we call. So whenever we go for a trademark, whenever we go for a symbol, it should be in such a way that it should be honestly adopted, honestly coined. It should not be similar to already existing mark, because it will dilute your mark. Okay, and eventually it will have hamper the commercialization of your product. Now, you also must have seen that TM and R certain times in, you know, in any logo. So R is only at those places when the trademark has been granted. Okay, but if, for example, you have filed for a trademark and the trademark has not yet been granted, in that case we write TM. Okay, so this is the difference between TM and R. Like similarly to patents and design, this is also, you can the same process is one thing over here about trademark is registered for 10 years. Okay, but those 10 years can be extended indefinitely. Like patents is for 20 years, design is for 10 plus 5 years. Trademark can be extended. Okay, because that's a brand name. Like Parle-G is there in the market for like, I think, more than decades. Now let's discuss about copyrights. Copyrights is something like a bundle of rights. I have not said it in when I talk of patent or trademark, but in copyright, it is a bundle of right. Why a bundle of right? Because copyright is an automatic right. You need not to register to our office for a copyright. For example, if you have written a novel, okay, or something, or any poem, you need not to come to our office that this is my work, I want a copyright over it. Once it has been done, it has already been granted copyright to you, that you are the exclusive owner of that. But basically, to, you know, save you from give you a legal backing. For example, if somebody do a case that we have seen in movies and the various songs as well, somebody might accuse somebody of, you know, stealing something. In that case, it is good to have copyright registered. Otherwise also, it is you are the creator, it's all right. So what thing is the creativity for copyright? Anything or something, whether it is a literary work or it is an artistic work, it's a dramatic work, cinematographic work, whatsoever work is, it should be creative, it should be original, and there is something called fixation. Fixation means it is not like if you think of a if you think of a line and you say, yes, I have made this line, I have made this very dialogue, now this belongs to me. No, you have to write it somewhere. After fixing it on a paper, after fixing it somewhere, only then it is called your copyrighted thing. Okay, so just having something in imagination does not give a copyright. So there are various features of the Copyright Act, like provisions related to the Copyright Office and registration of copyright, related to the statutory and compulsory licensing of the work, provisions related to the rights of owner of the copyright and tenure of protection. Like copyrights also have a tenure. It's not that if you write a book throughout your life and, you know, for hundreds and hundreds years to come, it will be copyrighted under your name. There is a certain tenure with that, which we'll see later on. Rights, performance rights, whatsoever that you hear in radio, whatsoever that you see in a television, everything comes under copyright. Okay, so these are certain subject matters of the copyright, like literary work, any novel, any book, artistic works, for example, dance or something, dramatic works, musical works, sound recordings, cinematographic films. Okay, all these things comes under copyright. Now there's this question people do ask, that director is all for example, if there is a movie, then director is the authorized, you know, person who has the copyright of that movie. It's not the director, it is the producer. Okay, now you can see a cinematographic film or sound recording, it is the producer who is the owner, right? Like in case of patents, we have inventor and applicant. In the case of copyrights, we have different works, different you know, owners of the copyright. Like literary dramatic work, author. For example, J.K. Rowling is the owner of Harry Potter series. Music work, It is the music composer like AR Rahman. Artistic work, the artist who does it. Photograph is the person who has taken the photograph. This is very obvious. Cinematographic film or sound recording, it goes to the producers. Okay, literary, dramatic, musical instrument, the person who has actually created the work in these cases. Okay. Now there's something called economic rights and the moral rights. For example, if there is song in a movie, you see that song, you hear that song in theater, but it does not mean that you cannot listen to that song in your mobile. You do listen to it on various apps, but you cannot copyright. You cannot, piratedly you can listen or hear that song through these apps. These are the authorized apps in which the owner of that copyrighted works gives economic rights. Okay. See, these are the transferable rights. It may be assigned to other owners for a sum of money or for the royalties, depending on the proposed usage of the work. So whenever there is a movie, they give distribution rights to various people. They give different types of rights so that their movie can propagate throughout India. But there's something called moral rights. These are the non-transferable rights. Very recently, a few months back, there was this very famous song, in fact, recreation of an old song, Bachpan Ka Pyar Mera Bhool Nahi Jana Re. We all must have seen that in somewhere at some social media platform. Now, a singer created that song, that is fine, but the moral rights are always with the original creator. Okay, you heard that song through that new singer, but nobody knew who was the actual singer of that. So that comes under moral rights. Moral rights is always with the original creator, and for the moral rights you have to search for the the original person who created that song. Like this song Oh Beta Ji, recently it became very famous, but the moral rights are always with the original creators of those songs, right? So these are the various scopes of copyright. Look, copyright is something like when you write something, it is not for your own purpose. It is something that should be dissipated to the masses. So there are different reproduction right, distribution rights, rights to create derivative works, right for communication to public, right of public performance. Like if you have created a drama, it can be performed publicly. It can be performed in theaters. Okay. And for example, there is a novel and movies are based out of those novels. So the director or the producer has to take permission of the author first. Okay. So that is where copyright comes. Now, this is like patents and everything else. There's also a timeline for copyrights. For example, published literary, dramatic, artistic, and musical works. The timeline is life of the author plus 60 years. For example, if there is a composer who composed a song and he died, and it's been more than 60 years, so you can, without any hesitation, use those lines for your own good sake, because now it is free for public. Films, sound recordings, these are given the copyrights only for 60 years from the date of publication. Okay. So after 60 years, every movie is free. You can use it anyhow way you want to use it. Similarly, the broadcasting rights, for example, anything that comes on the radio, that is there for 25 years, you cannot use it. But after 25 years, or design. It includes so many things. And second of all, you need not always have to register a copyright in our office. Once you, for example, on a social media or Instagram or Facebook, you write something, you place a photo, and there is a timestamp over it. Like you can see on this very date, on this very time, I published this. This time, that very date is also significant that this is your genuine work. Okay, but just to have a legal backing, there is a provision of filing for copyright. So these are also the fees like 500, 2000. Look, just look at the nominal fees. This is what government of India is doing basically. It is not for the patents, for technical work. It is also for those people who are into music industry, who are into theatrical work. They can also develop different dance forms and they can copyright it. Look at the fees. Cinematographic films, 5,000 only. Though they earn in crores, but the filing fees is only 5,000. Okay. So all these things have been done by the government of India just to improve the status of intellectual property, just to provide awareness so that more and more people are come together for development of our country, because in anyhow intellectual property is what makes a country develops. Okay. Now this is a similar procedure to the patent only. It's like application is received for the copyright, it's a formality check, just the formal examination, then the waiting period, then comes the scrutiny. In scrutiny, if there is some discrepancy, If there is no reply to that discrepancy, it is rejected. If discrepancy has been removed, then it is approved by Registrar General. Then if there is no issues with regarding to any objection from other person, it is directly granted. But if there are some issues with it, similar to patents only it is, there will be hearing, and after hearing, if everything goes well, it is approved. It is if there are some clashes, like there is a proof that this is not the original work, in that case copyright is rejected. Okay. Now, apart from copyright and all those things that we have studied, something is called geographical indication, and I'm sure this topic has become very evident these days, because everybody talks of this topic these days. When I was asked about to give a webinar to your institution, what I look for the GI tags of Gujarat, and I got to know this embroidery of Kutch embroidery. It has got a geographical indication tag. Rajkot Patola, it's a type of fabric, I think, from which sari is made. That has also received a geographical indication tag. So what is a geographical indication tag? Is basically, it indicates that a particular product belongs to a particular defined geography. Okay. It is an indication that identifies a product that has a specific geographical origin and possesses qualities or a reputation that are due to that origin. If I talk about history, India was very famous for muslin clothes in Egypt. India was very famous for the cotton production. Like it was called, I think, Manchester of India. This Gujarat, I think, Manchester of India. So cotton was so famous at that. Though GI tag was not there at that time, but cotton used to go from India till European markets. Okay, so that is what geographical indication is. So, for example, Darjeeling tea, Nilgiri tea. Okay. Makrana marbles. If you know Taj Mahal, the marble is also has a GI tag that is called Makrana marbles. So these are some of the various geographical indicators, GI tags of various products. Then Nagpur orange is also there. Kalam Save. In fact, these things are like when we travel. In fact, if, for example, a child, he has no idea about Ratlam Save, but उसे ये पता है कि लोग कहते हैं कि रतलाम की सेव बहुत अच्छी है. अगर ट्रेन बाहर रुकती है तो they fond of like search for it, and that is the power of intellectual property with regard to geographical indication, right? Makrana marbles, Darjeeling tea, Kanchipuram silk, this worldly painting, Kathputhlis of Rajasthan, Pattachitra of Bengal. Okay, so if there is something that you feel like of your community, of your regional area that is having that significance, you can file for geographical indication for that. Now, the thing is that geographical indication cannot be filed by an individual. Like patent, an individual or a company can file. Like design, an individual can file. Trademark also, and so is with copyright. But when it comes to geographical indication, because it does not belong to an individual, it belongs to a region. So group of people or a community of people, they file for it. Okay, not an individual. So I think up till now, what we can say is intellectual property is everywhere around us. If you can just look around you, everything, be it the plywood of the table, be it your mouse, the company of the mouse, be it the laptop, be it the mobile phone, the ringtone of your mobile phone, everything is related to intellectual property. It is just that we do not have the idea of how to put it forward. We create so many things, but we do not move forward for protecting it. Now the fees has been reduced, the awareness has also been given these days through various platforms. So I believe we also will be doing a share in enhancing the development of our country. So this was all about the intellectual property. Just once again a recap about the validity. Patents 20 years, design 10 plus 5 years, trademark 10 years initially, then it can be increased indefinitely. Then GI tag is also given for 10 years, but it can be increased indefinitely for 10 years. Now you must be knowing that famous case in which Bengal and Odisha were fighting. Who will be getting the GI tag for Rasgulla? Okay, so this is the power, because once you know that product is from that very company or that very area, there is some authentication with that product. Okay, like Mahabaleshwar lychee in Mumbai, it comes, it is famous. Nobody buys any other lychee. People only go for Mahabaleshwar lychee. So what I mean to say with throughout this lecture is we have to, while publishing, we have to protect it as well. We have to protect first, then publish. And whatsoever rights you get, that will be within the country, within the geographical boundaries of the country, that is India in this case. Okay, and the rights are for a limited period of time, and there are renewal fees as well. If I talk of the career opportunities, like we are working in government job examiner of patents and designs. Similarly, there are examiners of trademarks and geographical indication and the examiners of copyrights. Similarly, there are like private jobs as well. For example, patent agents, like if a person who's not able to file patent properly, it's not that they can do nothing. They will approach a patent agent. These agents are authorized by our office only. They can approach patent agent, and with the help of them, you can file a patent. Okay. And for further, there is this institution in Nagpur which provides further training regarding to intellectual property awareness. And in fact, regarding to any specific thing, for example, if you want some classes in an institution related to patents or trademark, you can contact this Nagpur institution. Now, before ending this session, there are certain few questions which I would like to say. You can definitely write in chat box. There are some famous trademarks which are hidden. Okay, if I hope I am able to convey myself. And these are the famous trademarks. Somebody or anybody can just tell me what are the famous trademarks that are hidden over here. Amul, right? Amul's there. And look, the power of Amul is there's this song, Pee Sakte Hai, Rose Glass Full, Doodh, Doodh, Doodh. That's the trademark of Amul. How they play these intellectual property rights with our minds. That is all for, you know, monetary and commercial benefits. Now, Amul is just one. There are so many others. 2, 3 only. Then I'll move on to the next slide. Okay.
Bata, sir.
Right, Bata is over there.
One participant said Pepsi, sir.
Right, Pepsi is
chat
also
box.
there. Right. Pepsi is also there. Right. So, you know, this is the power of intellectual property. Patent is something definitely related to technology, though it can be simple as a paperclip. But trademark is something even a, you know, 4th year kid of 4 years can also draw something and they will say, yeah, this is my logo from now on. So these are like Tata, Dettol, Babool, Bata, Horlicks, Amul, Pepsi, Cadbury, Link. Okay. Yeah, dairy milk with A. Correct. Now, these are the different IPs. So please tell me what is the IP of number 1? That's the famous Mona Lisa. What is the IP related with this Mona Lisa? Right? Patent or something? What? I'm not checking whether you have been listening properly or not. This is just a very common thing. So what is this Mona Lisa? What type of intellectual property this Mona Lisa can hold?
Copyright?
Definitely, it's a copyright. It's an artistic work. Then this second, this is a sculpture.
It's design.
It can come under design, but this is a particular sculpture of a person. This will come under copyright. It is an artistic work. Okay. Then this third, please tell me the third, intellectual properties in third one.
Trademark, sir.
Trademark as in that logo, right? Correct.
Yeah.
Any other? Look, there's this design of
also.
Apple.
Design also, all
Design. Now there's technology, there's screen, there's memory, there's so camera in it. Patent also. So this is a product which I like initially gave in my presentation. These products are those which have all the intellectual property rights embedded into one. Now this one, fifth one, please, if you can.
It's trademark.
Coca-Cola and distillery is trademark, right? This is a trademark. There is also a tagline, Coke opens happiness. Okay. And there's this how Coca-Cola is mentioned. The shape of the bottle, design and trademark as well. Now there's one more thing in Coca-Cola is, can we make Coca-Cola at home? No, we cannot. Why? Because there is something called trade secret. Now trade secret is something that is not disclosed to anybody. It is only known to the company. Okay. But the point is there should be some commercial benefit out of it. It's not like agar aap vada pav ya kuch bhi Gujarati dish, if there is any kakra, I don't know much. Aap dhokla acha banate hain, it does not mean you will be getting a trade secret out of it. You can get, if it tastes different, nobody else can make it, and there is a commercial benefit out of it, then you can get a trade secret of it. For example, the algorithm of Google, nobody knows, that is a trade secret. The Coca-Cola, nobody knows, that's a trade secret. KFC, nobody knows, that is a trade secret. Okay. Now, All right, these are like 2-3 more questions only. Which type of intellectual property protects the painting painted by artist? It's very simple, I think. Painting is protected by which intellectual property?
Copyright, sir?
It comes under copyright. Yes, it's a painting. It's not design. Look, in design, I said it should be an output of a industrial process. Okay. It comes under copyright, right? What protects the intellectual property created by fashion designer? It can come,
Participant said, sir, design.
yeah, it can come under design. It can come under copyright as well if it is a very particular type of drawing. It can come under both. Okay. Now, what protects the advanced disc brakes for bike developed by the inventor? This is very obvious, I think. It's not design. It is patent. It is advanced disc brake. This is a technology that comes under patents. Okay, nice. Which of these is a geographical indication?
Nagpur orange.
Like, correct. These are some silly questions, must I say.
Mhm.
What does a trademark protect? Logos, names, brand name. Right, correct. So we have discussed all these intellectual property, including patent, designs, and trademark, copyright, geographical indication. Now, there is one thing also called copyleft. There's copyright. There's something called copyleft, and I would leave it to you people because that is not that common. Everybody knows about it. You can just Google it. What is copyleft? Just for your reference, it is something that is available to all. Copyright is the rights given to your work. Copyleft is something that is available to all. I make a software, I'll make it public in Google. Anybody can come and download it. That comes under copyleft. Okay. All right. How long can a patent last? Well, I have repeated it multiple times. How long can a patent last? It's 20 years. Correct. If you write an original story, what type of intellectual property gives you the right to decide who can make and sell copies of your work? It is basically a copyright, because once you write something, once you write a novel, you give your rights to other publishers. Go and publish this. Somebody can make movie out of it. Okay. So these are different rights. That is why we call copyright as a bundle of rights. Imagine a cricketer sets up his own company to sell his own range of clothes. What type of IP can he use to show that the clothes are made by his company?
Participant said, sir, trademark, according to one participant.
Right. Look, it is a particular individual. Okay. It will definitely come under trademark because that's a brand name associated with that cricketer. For example, being human.
Yeah.
Right. We all know who made that. So, right. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? If a company develops a new technology, yes, that is patent. So this question is over there just to make you understand that patent is not only for something new, it can be an improvement over previous invention. Okay. Like it's written, improves its main product. Product was already there, patent was already there, but it was an improvement. So thank you so much for your patience and time and for listening it.
Thank you so much, sir, for this informative session. Now we have some questions from the participants.
Right, sure.
Yeah. So first question is from Pandey Khushi. He asked for patent can be granted for what? Like she is writing.
Am I visible? First of all, please can you tell
No,
me?
sir, you are not visible, sir.
Just a minute.
Am I audible, sir?
Yes, you are audible. Okay, please go on. It's okay if there's no video. I don't know what's wrong with it. Okay, anyways, continue, no issues.
Okay, sir. So there was one question from Pandey Kushi.
Right.
That patent can be granted for what? That is the question
Patents
from
can be
Pandey.
granted for what?
Yeah, that is she written.
Patents, like I have said, it is basically granted for an invention, for a technology. Okay, it can be a new technology, it can be an improvement over other technologies. So for all those things, like I have, I think in throughout the PPT, I have been saying that literary works comes under copyright. If there's a design logo, that comes under trademark. So similarly, technological advancement comes under patents.
Okay, sir. There is another question. A
Right.
complete specification once filled, is that absolute or not?
Look, there are certain changes are allowed. Okay, there are some forms through which you can do certain changes, but the changes should not be that you have completely changed your invention. Okay, there should be limitation. If your invention is related to a particular technology, it is not that by those changes you have totally deviated from what you initially filed and what you have finally filed after changes. So changes are there, changes can be done, no issues,
Okay.
but within the range of your description.
Okay, sir. And another question is from Ashu. Is it necessary to disclose our technology in full detail, or we have to explain it all?
Well, what the act says is you have to disclose it, so that any person ordinarily, having ordinary person with skill in the art, they can also understand it. It should be at least that much disclosed.
Okay.
It is not कि आप कुछ नहीं देंगे तो patent मिल जाएगा. You have to disclose it somehow that ordinary person can understand it. Okay.
Okay. So this is all the questions. So anyone else who want to ask some question? Any
Yeah.
participant? Yes.
Actually,
Sir.
I have multiple questions.
Yeah, sure.
Yeah, first one is it's related to patent. So when you are publishing any paper in research article, there is one importance of author sequence, like first author, second author, third author, and they have different weightage. In case of patent, when we are filing the patent and subsequently it is granted and published, let we have 5 inventors. So is there any weightage of the author sequence, or it will be understood that all the inventors are having the equal weightage? Like
Look,
someone is
look, first of all, that's why I mentioned form 5. Form 5 is the declaration of inventors. The applicant declares that these are the individuals who have created the patent. Okay, and there will be an assignment, or we can say paperwork, between the inventors and the applicant. These people work under me, so and they are happy to give me the right. But it is the patent is granted for applicant. Okay, it is used under the name of applicant only. But definitely you're also part of it. In fact, after filing form 8, your name are also mentioned in the patent, that the patent copy that we give it to you now, the name of the applicant as well as inventor is also mentioned. But solely saying that I am the sole user of person who can use this patent, this cannot be done, because other people are also a party of it. But तो case हो जाएगा sir.
So the second question is related to GI tag.
Right.
So while you have explained the GI tag, you put the controversy between Odisha and Bengal.
Mm-hmm.
In that context, I want to know, in that controversy, we had given a GI tag to both Odisha and Bengal. How we had given? We had given based on the texture. Like it's called Odisha Rasgulla, another is called Bangla Rasgulla. If the texture is spongy, it's Bangla Rasgulla. If the texture is soft, then it's Odisha Rasgulla. So my point is that if the same techniques, any country outside India will adapt, and they say that it's our product. So based on the having the GI tag, can you do? Can we file any case, or can we stop the manufacturing process? Or another thing is, from the GI tag, is there any commercial benefit to the state? Since we are unable to file the GI as an individual, we can file from the state. So is there any commercial benefit to that? Or only we are getting the recognition?
Look, I said earlier when I was doing my presentation, there is a difference between a common person and a businessman. Like when I did my master's, like I had tried and academically I did sound, but from the mindset of a businessman, there are so many things like commercialization. Okay. Now, GI tag does not mean it just give you a reputation. Like reputation, आप क्या करोगे reputation का? What the outcome of that reputation is, people from far flung countries and far flung areas come to your place कि यार we have heard that this particular product is very famous of this very area. अगर let's say you are a tea drinker and somebody will say कि मैं आज आपको दार्जिलिंग की चाय बनाऊंगा, दार्जिलिंग चाय पिलाऊंगा, so you will have that smile on your face कि हाँ, if there are multiple चाय you will select नहीं यार नीलगिरी की चाय पीनी काफी फेमस है. So that is how these geographical indication tag works. It gives a recognition of a product. Okay, and once the product has been recognized, people actually go for that only. Like I give you an example in Mumbai, like I'm in Mumbai, so so many lychee comes, but Mahabaleshwar lychee, when it is written on the box Mahabaleshwar lychee, so I particularly buy that one because that is a geographical indicator tag of lychee from that very area. Nagpur ka orange. So this is how, this is basically to make a market. GI tag, otherwise there's no point of GI tag. Throughout the world people are wearing clothes, throughout the world there is everything, but just to make your product particularly famous, that is what GI tag is given for. And in fact, like I said earlier, I just said an example, like muslin from India, it was exported to Egypt. It was very famous in fine cloth that was used by royal families. Cotton, Europeans used to export cotton, and earlier this dye, there was some dye also which was exported from India only. So though GI tag was not there, but people do understand that this is the best of the best quality that is available. So that is why they used to come to that India and for that very particular product. So how, that is how we GI tag can be used for commercial purposes, and that is what's the whole concept of IP is, intellectual property. The right is only because so that it can be commercialized. Otherwise there is this is just something that comes from intellect. There's no right attached with it. Okay, so right is given so that you can commercialize it.
Thank you.
So what's the whole point of all this presentation is, we come across multiple problems, and a single individual can have multiple solutions to one problem as well. How can we use those solutions for the development of ourselves, for the society, and for the nation as well? Like those example, 1919, 1856, हम में से किसी को आइडिया भी नहीं होगा पेटेंट्स का उस टाइम पे, बट दीज वर द पीपल, वेस्टर्न कंट्रीज, दैट इज व्हाई दे आर डेवलप्ड, बिकॉज़ दे हैव दैट टेक्नोलॉजी. So it is all about developing things and registering things and making commercial use out of it. It is the economy that runs every country. Okay, yeah.
Okay, sir, there is one another question from Bhavik Patel. Can we send idea as patent?
Can we send idea as patent? No.
Okay.
देखो idea मेरे पास भी है कि I want to go to Mars, but I cannot do patent on that. I have to make a rocket for that first. Okay, so ideas cannot be. In fact, in copyright also I said it has to be fixed. Okay, just you think in a mind, आपने बहुत बढ़िया dialogue अपने दिमाग में लाया, तो वो copyright नहीं होगा. You have to write it somewhere, then only you will get a copyright over it.
Okay, thank you, sir. So I want to ask to participants, is there any more questions? Anyone else who want to ask some questions? You can write in chat box also and Q&A session also. Okay, so I think there are no more questions. So now, thank you so much, sir, for this informative session. Now I invite Dr. Namrata Bajaj, ma'am, for vote of thanks. Ma'am, please.
Thank you, Jyoti, for inviting me for tendering vote of thanks, especially on the occasion of World IP Day, when AICTE has given the consent through Mr. Anshul Verma. He is from Indian Patent Office to deliver this session. We were really excited. So Indrashil University thanks AICTE as well Indian Patent Office from where Anshul Verma is associated with, and he is expert and examiner for design and patent. Thank you, sir, for this wonderful, informative, highly informative and significant session where we came to know about patent, copyright, design, trademark, everything, and you differentiated also along with the features associated with them. Of course, you have given us the insight on the basic definition also, which was very important, and how India can scale up further from 80 to 48 to maybe, in top 10 also, because India is known
Right.
for its jugadu, intellect also. So it was
Right.
wonderful, sir. And jugadu is, of course, I don't know, it comes under which category, sir, patent, design, trademark, or copyright. But then,
Ma'am, if that is not there in any other country, then definitely patent will be granted for that.
and GI also, which was very informative, sir. Maybe you gave us our homework also, KAPILA also for that, right? Apart from copyright, so that is what. So we will definitely explore that also, because Indians are highly intellectual, and it's high time now to scale up further from 48 amongst top 10. That is how we can come under the category of developed country. Thank you so much, sir,
Right.
and I also thank you for answering well to all the questions, to the queries which has been raised. And thank you everyone, now starting with the management of Indrashil University, who gave us opportunity to attend this and gain information, valuable information from this. I also thank Dean, School of Engineering, Dr. Amish Vyas, coordinator for this session, that is Dr. Siddeshwar, Ms. Jyoti, and also the technical team, Mr. Shashwat, and everyone who was directly, indirectly involved in organizing this activity, this session, wonderful session. I thank everyone, and to all the participants who actually made this event and this webinar, very successful. So thank you all, and Indrashil University wishes you safety and health. Jai Hind.
Thank you, ma'am. Jai Hind, ma'am.
Thank you, ma'am. Uh,
Thank you,
Shashwat,
Anshulji.
Showing the integration of the different styrene indicator to styrene derivatives and also the benefit matter by utilizing the
Shashwat sir, can we wrap up the session now?
Jyoti, they are facing net issues, so let us leave now.
Okay, sir. Okay.